whether you wear a badge or not. If you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, a police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report.
Hello, and welcome back. This is the Conditions Report, episode 18, Asphalt Memory, Carroll's Precedent, and the Automobile Exception. I'm Don, and this is the Conditions Report. If you've already been listening to the show, well, you know the premise. And if you're new here, here's what you need to know. This is the weather forecast for street cops, detectives, and admin. What's coming, what's changing in the environment that we work in. Before we go any further, a quick disclaimer. I'm not an attorney, and nothing discussed in this show is legal advice. I'm not speaking on behalf of any government agency or law enforcement organization. The views expressed here are mine and those of Forecast Securities Group exclusively, and they're an exercise in protected American free speech. If you need legal advice or guidance on specifics to your agency or jurisdiction, you should consult qualified legal counsel. This podcast is for educational and informational purposes only. We're not here to judge the officers involved in the incidences or to second-guess decisions with the benefit of hindsight. The point is to learn from their hard-earned lessons on our behalf and improve as a team. In this episode, we're going to go back to the fall of 1923 on a Michigan highway linking Grand Rapids and Detroit. Federal probation agents stopped George Carroll and John Carroll in their Oldsmobile Roadster. No warrant was in hand, but months of surveillance, a prior undercover purchase of liquor, and the unmistakable feel of hidden bottles beneath the seat led to a search that uncovered 68 quarts of bonded whiskey. Convicted under the National Prohibition Act, the men appealed to the Supreme Court, and on March 2, 1925, Chief Justice William Howard Taft, writing for the majority in Carroll v. U.S., upheld the warrantless search. He established the automobile exception, stating probable cause to believe a vehicle contains contraband combined with the inherent mobility permits a search without a warrant. A century later, this doctrine governs countless roadside encounters. The Constitution and leadership stakes are unchanged and balances practical enforcement against the ancient protection from unreasonable intrusion or risk eroding from the very trust that we work to maintain. Let's get into the situation brief. Let's go back to the highway between Grand Rapids and Detroit in the early autumn of 1923. Leaves turned gold and drifted across the road as George Carroll steered his Oldsmobile Roadster eastward and John Carroll beside him. The rumble seat held more than luggage, and beneath the upholstery, pulled taut to remove filling and false panels, 68 bottles of bonded whiskey rested in their glasses, cool and silent against the motion of the road. 3 months earlier, in a second-floor apartment above a bookstore in Grand Rapids, federal prohibition agents Fred Cronwet and John Scully had posed as Canadian buyers. They met Carroll and Carroll, purchased several cases of liquor, and counted out cash, and listened as Carroll promised steady supply on future visits. The agents noted everything: the confident manner, the specific car with the dented fender, the route it took, and they did not return as customers. Instead, they watched the highway, the known arteries for bootleg trafficking from Canada, where liquor flowed legally but across the border as contraband. On October 2nd, the same roadster appeared again, moving with a familiar rhythm. Cronwet and Scully and another agent, along with the state officer Thaddeus Peterson, recognized it instantly. They fell in behind, followed it briefly, and then signaled the stop. Carroll eased to the shoulder without resistance, and both men stepped out, hands visible and faces steady but watchful. Cronwet approached the car. He pressed a hand to the rear seat cushion. It resisted unnaturally, too firm for ordinary springs. With his pocket knife, he slit the fabric, and bottles gleaming in the pale light, labels intact, some bearing certificates from England chemists claiming blended Scottish whiskey. The sharp scent rose into the chilly air, unmistakable. Carroll reached for his pocket, offered money, and spoke quietly of leniency. The agents declined, and handcuffs closed. The men were arrested on the spot for transporting intoxicating liquor in violation of the National Prohibition Act. At trial, the federal district court in Grand Rapids, the defense counsel argued with a measured force. The automobile, he said, was a private conveyance entitled to the same safeguards as the dwelling. The founders could never have foreseen machines of such speed and freedom and yet intended lesser protection for them. Cronwet took the stand detailing the prior sale in September and recognition of the vehicle on October 2nd. On a known smuggling route and the tactile discovery, he testified that the upholstery had been slit only after the firm feel confirmed hidden compartments. A jury weighed it all in. In the control by, the highway pattern, the hidden cargo, they convicted Carroll and Kiro. The prison sentence followed, stern enough to mark a life. Appeals climbed steadily, and by December of 1923, the case reached the Supreme Court on a writ of error. Arguments were heard in March of 1925, and the courtroom was thick with agents, attorneys, and reporters. Counsel for Carroll emphasized the Fourth Amendment's absolute language, arguing that automobiles deserved full warrant protections, just like homes. The government countered with historical precedent of warrantless carriage searches for untaxed goods, and Chief Justice Taft, who had served as president and a circuit judge, delivered the opinion for 6 justices. The search was reasonable, he wrote. Mobility created practical necessity. Probable cause provided the constitutional boundary, and the convictions were affirmed. Justice McReynolds and Sutherland dissented, seeing no principal distinction between a car and a fixed structure, yet the majority held. And from that quiet shoulder, where a glass caught the light and a principle met reality, a doctrine took hold that would guide law enforcement for generations, influencing everything from traffic stops to border patrols. Let's get into the current conditions. The Fourth Amendment declares that people are secure in their persons, houses, papers, and effects against unreasonable searches and seizures, with warrants issuing only upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the person or things to be seized. The language is absolute, yet reasonableness has long accommodated circumstance. In Carroll, Chief Justice Taft captured this distinction. He wrote, quote, "The guarantee of freedom from unreasonable searches and seizures by the Fourth Amendment has been construed, practically, since the beginning of government, as recognizing a necessary difference between a search of a store, dwelling, house, or other structure in respect of which a warrant may be readily obtained, and a search of a ship, motorboat, wagon, or automobile for contraband goods, where it is not practical to secure a warrant because the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant must be sought." Taft anchored this in history. The first Congress, which proposed the Fourth Amendment, authorized warrantless searches of vessels and carriages suspected of untaxed goods under statutes like the Act of July 31, 1789. In Carroll, probable cause arose from the undercover purchase in September, the recognition of the specific vehicle on October 2nd, and a known smuggling route, and Cronwet's confirmation of hidden compartments. The exception rests on 2 pillars: probable cause, which is an objective fact sufficient for a prudent person to believe contraband or evidence is present, and the inherent mobility, creating an exigency. The doctrine has evolved with care. In Chambers v. Maroney in 1970, it permitted officers to seize a vehicle upon probable cause and to search it later at a secure location. Exigency persisted beyond the roadside, and the facts involved in the late-night robbery. Officers had descriptions of the suspects and the station wagon they used. Probable cause justified the initial stop and later search at the station. Justice White wrote for the majority that the circumstances that furnish probable cause to search a particular auto for particular articles are most often unforeseeable. Moreover, the opportunity to search is fleeting since the car is readily movable. In United States v. Ross in 1982, it extended to containers. If probable cause justifies searching the vehicle, then it justifies searching every part and container that might conceal the object. Justice Stevens wrote, "The scope of warrantless search authorized by the exception is no broader or no narrower than a judge could legitimately authorize by a warrant." In this case, involved a tip about a drug dealer. Officers stopped the car, searched the bag and a leather pouch, and found heroin and cash. In California v. Carney, 1985, it applied to motorhomes in a public lot. Citing that mobility and reduced privacy expectations in vehicles, Chief Justice Berger wrote, "The vehicle's capability to be moved and the lesser expectation of privacy resulting from its use and readily mobile vehicle justified application of the vehicular exception. California v. Azevedo in 1991 resolved prior inconsistencies from cases like Arkansas v. Sanders, where containers sometimes required separate warrants. Justice Scalia, for the majority, overruled those limits. When probable cause exists to the vehicle, it covers containers within. The facts: police observed a bag they knew contained marijuana placed in the trunk, and they searched it without a warrant and seized it. Collins v. Virginia in 2018 drew a boundary. The exception does not permit warrantless entry onto a home's curtilage to search a parked vehicle. Justice Sotomayor wrote, "The automobile exception does not give officers unfettered access to a home's curtilage simply because the vehicle is parked there. Officers entered a driveway to lift up a tarp on a motorcycle, and the search was invalid." No Supreme Court decision has overruled the core exception for vehicles on public roadways. As of early as 2026, electronic warrants narrow some exigency claims, but mobility remains a factor. State courts occasionally interpret their constitutions more restrictively, such as Pennsylvania in the Commonwealth v. Alexander, requiring exigent circumstances beyond mere mobility. But federal doctrine endures, and recent federal cases affirm. In U.S. v. Ostrom in 2024, standing was denied for a stolen vehicle, but the exceptions applications were noted. A 2025 Iowa Supreme Court decision rejected abolishing it underneath the state constitution, citing federal precedent. Probable cause is an unchanging safeguard. Particularized, articulable facts judged objectively at the moment, never a hunch, profile, or pretext. The exception is narrow and a departure from the warrant rule. Justified by practicality and rooted in reasonableness, it authorizes action when evidence might vanish, but demands precision to prevent abuse. That brings us to our leadership navigational aid. The greater the power, the more dangerous the abuse. Edmund Burke said this in 1771 on the floor of Parliament, warning against overreach in governing the American colonies. Burke was a conservative statesman and a philosopher who championed prudence, tradition, and restraint. He was against authority that outruns its own limits, especially when wrapped in righteous purpose. His warnings came from watching power feel like justified and growing unchecked. This dynamic plays out every time we apply the automobile exception. The power is practical and needed. Mobility creates real exigency, and probable cause justifies the search, but greater power invites greater risk of abuse. Not overt malice, but the slow creep of habit, the assumption that if we can, we should, and the pressure to turn every stop into a score. Consider the roadside reality. Officers face this at 0300 on a dark interstate shoulder, the faint odor of raw cannabis, prior intel from narcotics that may be days old or loosely connected. The automobile exception is there, clear from Carroll, forward. The temptation is real too, to open every container, to push deeper because the vehicle is, quote, mobile, and the facts feel close enough. Yet the same agencies that celebrate big seizures will later dissect the probable cause under bright courtroom lights, or on body cam review when a citizen's complaint comes. One overboard search risks the suppression of evidence at trial, civil liability, and community backlash that lingers long after this case closes and officers carry the weight of a career hit. Supervisors, you are the brake in the system. Your role is not to maximize lawful intrusion for stats or optics. It's to ensure that power stays tethered to facts that survive scrutiny. You build on that discipline through relentless practical training. Make officers narrate probable cause out loud on camera until it becomes muscle memory. Odor of burnt marijuana from the passenger compartment, driver's inconsistent answers about recent travel, a canine alert on the trunk. You reinforce it in debriefs and ask hard questions without accusation. Why the glove box? What stopped you from going further into the panels? You shape the culture by rewarding the officers who close the trunk when the facts run out, not the ones who push because the exception allows it. The greater the power, the more dangerous the abuse, and restraint in these circumstances is not weakness. It is leadership that keeps the badge credible, keeps evidence admissible, and keeps officers safe from unnecessary burden and escalation. Burke's warning was not a call to shrink from responsibility. It's the opposite. It was a call to exercise responsibility with your eyes wide open. In our world, that means supervisors who understand the exception is just a tool. It is not a mandate. It needs to be used precisely, so teach it precisely. Review it precisely, and when we let power run unchecked, even with the best of intentions, the cost is often paid by people we lead and the people we serve. So, a century after Carroll, Highways move faster, vehicles carry embedded intelligence, and warrants arrive via tablets in minutes. Electronic affidavits and remote judges shrink traditional exigency gaps, yet the core tension holds. Contraband still disappears if action is delayed. Autonomous features and encrypted compartments will test, quote, ready mobility in ways that Taft never imagined, while body worn and in car cameras create indelible record of probable cause formation. So future courts will parse those records frame by frame, weighing whether the facts crystallize before intrusion, and the training must evolve alongside. The scenario drills incorporating digital tools and regular updates on technology and law shifts. Consistent emphasis that the exception remains narrow, not routine. The boundary between reasonable and unreasonable stays thin and drawn anew on each and every traffic stop. Our task is to walk it with care, to build facts deliberately and document transparently. Act decisively only when justification is clear and articulable. And as we close, let's remember the point of the show is not to pass judgment or to revisit the decisions with the benefit of hindsight. It's to learn as a team and to improve. We're all leaders, so keep the L&A in the back of your mind. The work is complicated and the environment is demanding, and none of us get it perfect. Stay hungry, stay humble. I'm Don, and this has been the Conditions Report. Be the calm in the storm and the clarity in confusion, and always influence the weather.